I find Taylor really interesting too, because as I discussed on the podcast, there's this whole discussion that Justice Gorsuch gets into about the realistic probability test, which is essentially this whole thing where you can't win even if the statute is broader than a removable offense, unless you can find a case where the state or the federal government are applying it in an overbroad manner. And I'm going to get to this more in a sec, but Justice Gorsuch seems to be saying that all of that is irrelevant and unnecessary, and Duenas-Alvarez does not apply in contexts like this. And Duenas-Alvarez was the immigration case that created the realistic probability test. So I'm not going to get into it so much here. I get into it on my podcast, but there's a lot of language to argue that the realistic probability test is never a sword to harm non-citizens with. It's a shield for non-citizens to use. That's what Duenas-Alvarez was saying. When it seems like they're removable, but they can find a case to show that they're not. Mm-hmm. It's really been used as a sword most recently by the Fifth Circuit and the board, but you get these bad decisions on it from certain panels from all the circuits all the time, and it's really confusing. I can only imagine the Supreme Court's going to take it up within the next couple of years, because there's currently a circuit split anyway right now. The Fifth Circuit at a minimum applies it differently than all the other circuits. So I think we've got a favorable court on it. So we'll see what happens. So United States v. Taylor, very interesting for all those reasons. Yeah. And I hope you're still following.
I did lose you halfway there, but it's interesting with the way the Supreme Court is, and with immigration, you never know which way this stuff's going to pop out.
Yeah, Justice Gorsuch really does seem to be a friend when it comes to the realistic probability test, and just, you know, the statute says what it says. This is the area where, like, the strict statutory construction that this Supreme Court seems to be, probably for the rest of your and I's lives at this point.
Yeah,
this does benefit non-citizens. Yeah, because states write their statutes usually to criminalize the most conduct possible, which is then what you can use as a removal defense attorney or USCIS counsel to show that, no, the statute covers too much conduct vis-a-vis the removable offense. So this strict statutory interpretation it's a benefit to non-citizens. Justices Thomas and Alito say in Taylor that they want to get rid of the categorical approach entirely, but that's only two justices. Nobody else said that.
Yeah. Well, they go a lot behind the scenes. We'll see what happens.